All right, if everyone can take their seats, we can get started with this conference's annual review of healthcare enforcement and the False Claims Act, which never ceases to be in high demand here. And we're very fortunate for my fellow co-chair Brian McEvoy to be leading this panel. Most people in this room know Brian, who's really one of the most extraordinary False Claims Act and healthcare enforcement lawyers that you will find anywhere. He's a graduate of Georgia State College of Law, and he went to Boston College undergrad. He is head of office in Atlanta for Polsinelli, and he is national white-collar leader for Polsinelli. And Brian every year brings his unique and detailed perspective to developments in healthcare law and healthcare enforcement to this conference, for which all of us are very grateful. Brian?
Thanks, Mitch. Yeah. I'll pay you later. All right, so we recognize that this is a white-collar conference, and we're talking about, for the most part, federal criminal cases. And we also recognize, as we have historically, going back particularly to the parallel proceedings policy announced by Leslie Caldwell several years ago, which really enhanced the relationship between the civil DOJs and civil Department of Justice attorneys and criminal Department of Justice attorneys. And so, we think each year, given the evolution of the case law and some of the related policies that the Department of Justice is putting out each year with respect to these cases, that it's important to sort of go over the groundwork and some recent developments, not just in False Claims Act cases, but in some of the parallel criminal proceedings, and then some of the policies that flow therefrom. And we're very fortunate to have a terrific panel today that I just want to take a minute to introduce, starting with Kristen Thaler, who we're very happy has joined us. She is a partner at Quinn Emanuel and has offices in Los Angeles and Washington, D.C. Kristen has a national practice, including white-collar criminal defense, internal investigations, and FCA matters. And not only does Kristen do some healthcare work, but she's also developed a reputation for a lot of non-healthcare False Claims Act cases, which I think we're going to hear some about today. And to Kristen's right is Jack Selden. Many of you know Jack. Jack's been a big friend of this program for many years, and we're happy to have Jack back. Jack is a partner at Bradley in Birmingham. In addition to being a former assistant United States attorney, Jack served as the United States attorney for the Northern District of Alabama, and while he was there, I think created the Affirmative Civil Enforcement Group, which now has one of the best practices around in terms of bringing False Claims Act cases. So thank you, Jack, for being here. And to my immediate right is Tom Gregory. Tom is a partner with the Forensic and Integrity Services Group at E&Y, Ernst & Young in Atlanta. Among other things, one of Tom's practice, and I don't envy you for this, but one of Tom's focuses is advising companies on quantifying damages in FCA cases. So I imagine those are not very fun conversations to have. So thanks for being here. And to my left is one of the foremost experts in False Claims Act litigation in the country, Robert Salcido from Akin in Washington, D.C. We're very happy to have you here, Robert. Robert was a trial attorney with the Department of Justice in the Civil Fraud Unit from 1988 to 1993. He has worked on FCA cases and tried FCA cases all over the country, and literally wrote the book on False Claims Act litigation, or at least one of them. So thanks for being here, Robert. Thank you. And then last and certainly not least is my friend Sandy Weinberg. Sandy is a partner at Zuckerman Spader in Tampa. Sandy's a former chair of the criminal justice section and also has been a big proponent of this program. Sandy's got not only a white-collar practice and a healthcare practice, but also a robust False Claims Act and parallel proceedings practice dealing with other regulatory and criminal matters. So throughout the group, we've sort of got all bases covered. And as we're kind of going through the agenda today, please don't wait till the end to ask questions or make contributions if some of you in the audience have observations or experiences of your own. And sort of to get things started, I thought a good place to start would be with Robert and talking about Escobar, sort of 2 years on, and what has happened since Escobar with respect to, the materiality standard, how that's been applied by different district court cases and circuit court cases, and how that has affected and how it may affect prosecutorial decisions going forward.
Thank you, Brian. As Brian noted, I started at the Department of Justice back in 1988. So I was with the Civil Fraud Section, which, as many of you may know, has nationwide jurisdiction over the False Claims Act. So the first 5 years of my career, I did nothing but False Claims Act cases. And then for the next 25 years in private practice, I've done nothing but False Claims Act cases. And in my view, the court decision in those 30 years that has had the greatest impact is Universal Health Services versus Escobar. The case that Brian, Supreme Court case, 8-0 Supreme Court case that Brian just alluded to. The case is significant in a few respects. One is what the court said rhetorically was very important about the False Claims Act, and that is that the False Claims Act wasn't intended to address garden variety regulatory and contractual disputes. The Supreme Court also said that the False Claims Act wasn't a super fraud statute intended to enforce all other rules, regulations, and standards that exist. And just to give you one example of what perhaps the court was alluding to is you'd even had cases under the False Claims Act where there would be a manual provision saying that a physician had to hand sign the record for the record to be deemed complete, and the physician instead would use a rubber stamp, and actually there'd be False Claims Act action saying that the physician's claim form was a false claim because it didn't conform with rules and regulations governing the program, and the physician did so knowingly. And you're getting False Claims Act cases like that. Another principle that the Supreme Court spelled out was that the False Claims Act is, in essence, a penal statute. And because it provides for treble damages and the potential for massive civil penalties, that it wasn't intended to be used for trivial violations of rules and regulations. That was kind of the lead up to what is actually the most important ruling, I think, of the Escobar decision. And that had to do with the fact that the false claim itself had to be material to the government in order for the False Claims Act to apply. So the way Escobar changed the world, the False Claims Act world, is before Escobar, materiality wasn't really an element that was focused on. There was really two lines of decisions having to do with False Claims Act materiality pre-Escobar. One, which was by far the majority rule, was the natural tendency test. And what courts said there was that they would apply an objective standard in assessing materiality. They would look to whether an objective government official would be influenced by the false statement in making a decision about whether to pay that particular claim. And not surprisingly, most courts putting themselves in the shoes of a reasonable government official found that the government official reimbursement decision could be impacted by the alleged false statement. There was a second school of thought, but it was just a few cases, and the cases were most noteworthy in the sense that they were frequently criticized, and that was an outcome materiality test, where courts would look to the actual behavior of the recipient of the false statement. Not so much an objective standard, but subjective as well. Now, the reason courts criticize that, the vast majority of courts again, is they would say, well, you can't leave the decision-making to a single government bureaucrat to determine whether the decision would have been material to the government. That's not the proper way to approach materiality. Where Escobar changed the world is Escobar said no, that in order to determine materiality, you either look at the likely effect or the actual effect on the recipient when the recipient received or became aware of the alleged false statement. So why is that important in the False Claims Act world? The reason it is so important and had such a dramatic impact in the False Claims Act world is because of the structure of the False Claims Act. As many of you know, the way the process works is the qui tam relator files the action under seal, provides the government with a statement of material evidence. The government then, for at least 60 days, and we all know it's frequently extended, sometimes over years, will study the allegations in great detail. In fact, the statute itself sets forth an affirmative duty on the government. The Attorney General shall investigate actions brought under the statute. So the government investigates after becoming aware both of the relator's complaint and the best evidence the relator has to support the allegations. So if you couple that process with the Escobar ruling, where Escobar is looking at the actual impact that the false statement had on the government, the burden that imposes on any plaintiff going forward, especially in cases where the government doesn't intervene, is the notion that the government is aware of the alleged allegations. So what did the government do? Did it renew the defendant's contract if the allegation was that they made false representations under the terms of the contract? Did it award the contractor a bonus in performance? Did it take, once it became aware of the alleged falsity, did it take any administrative action against the contractor of any type? Or did the government do nothing? And again, as a former DOJ lawyer, and many of you who have participated in this process frequently will also know, in the vast majority of cases, historically about 75% of the cases, the government doesn't intervene. And in a significant amount of those cases, not only does the government doesn't intervene, but the government doesn't take any action as a result of the relator's allegations of any type. So if this fraud was committed against the government, and you have responsible government officials who's charged for safeguarding government programs, they become aware of the fraud and they do nothing, then it becomes difficult for the plaintiff at that point to satisfy Escobar's test, at least without blushing. So that's the reason Escobar has become such a powerful tool. And it's creating, in that regard, for the most part, great precedent. But to give you another example of the great power of Escobar, I can discuss briefly two cases, both of which are cases that I worked on that have resulted in a published decision over the last year. And these two cases, because of Escobar, has resulted in $1 billion in judgments being reversed. That's the power of Escobar. The False Claims Act in fiscal year 2017, the government, and again, the False Claims Act is the government's primary weapon to police fraud. In fiscal year 2017, the government recovered $3.7 billion. It would have received $1 billion more, at least in the two cases I'm about to reference briefly, but for Escobar. So one case, I was trial counsel in United States ex rel. Ruck versus Salis Rehab, which was tried in the Middle District of Florida, Tampa. And the relator had alleged that among the defendants' 50 skilled nursing facilities had engaged in a massive fraud, some of which had to do with care planning and faulty documentation and things of that sort. The relator alleged ultimately $1 billion claim. Once the dust settled and the jury came back, the judgment ended up being $347 million. What was clear from the evidence presented at trial, when you review Judge Mereday's decision, is that the relators, at the end of the day, did not put in sufficient evidence to satisfy the materiality standard as articulated in Escobar. And what I mean by that particularly is we, because of Escobar on the defense side, we put in evidence that at the 50 skilled nursing facilities that were subject to the lawsuit ultimately, there were more than 1,000 surveyor visits from state officials that inspected the facility. Notwithstanding the detailed surveys that were conducted over the relevant time period, very few significant violations were ultimately identified, and the government certainly never took back or denied payment on any claim as a result of any of these infractions. We put in similar evidence in terms of the government knowledge, but notwithstanding any government knowledge, the government never going back and demanding any type of repayment. Ultimately, that persuaded the judge in terms of finding that notwithstanding evidence we put on the defense side of government knowledge and government inaction, the relator then failed in the relator's duty to present countervailing evidence that would demonstrate that, in fact, if the government had truly known of the allegations, the government would have denied payment. So the court vacated the $347 million judgment and awarded judgment for the defendants. Briefly, I think it's worth noting the second case, United States ex rel. Harmon versus Trinity, which was a $663 million verdict for the relators. And this case, the reason I think it's useful to spend at least 2 minutes with it is it goes to a fundamental strategic decision, which I frankly don't know the right answer to. And that is what happened in Trinity, which had to do with the allegations of the relator that the defendants had sold guardrails to highways. You all see them on the highways as you drive, that were ultimately defective to the United States government. Now, one strategic consideration in non-intervened quitam cases that everyone confronts is whether to call any government folks as witnesses. Now, one of the reasons why historically, pre-Escobar, I shied away from deposing government witnesses is for the simple reason you don't know what they're going to say. Obviously, you have on the defense side no opportunity to prep them, to discuss the case with them. You don't know if, when deposed, they're going to come out and say, absolutely, had I known of that false statement, I would have never authorized payment on the claim, or whether they're going to say the opposite. So generally, I would not depose them. I couldn't control what the relator would do, but I would try to set up a record to win the case without getting that type of evidence. Interestingly, what happened in the Trinity case was before trial, the relators made a TUI request. Because the government's a non-party, you have to go through the TUI process, to take a 30B6 deposition of the government regarding the safety of the product and whether the product was qualified for payment. So in lieu of testimony, what happened was the government, through the Federal Highway Administration, submitted a memo which said that to the government, and what they meant by government was government with a capital G, not some GS9 bureaucrat, but to the government, the product was qualified and had always been qualified for payment, including the time period the relator said that defective guardrails were sold to the government. So you have the situation there where on the one hand, you have government experts who don't have any financial interest in the matter, who's charged with safeguarding government programs, say that the product is safe and the government will purchase it. And you have, on the other hand, a financially self-interested, non-politically accountable relator who says that the product is entirely defective. And in that battle, a court has to decide whose judgment is going to prevail. In applying Escobar, of course, the Fifth Circuit ultimately concluded that the government's viewpoint prevailed in the sense that the relator didn't provide evidence to show that the government's decision-making was somehow corrupt. And since the government decided whatever alleged falsity occurred with respect to the submissions regarding the specifications of the product, the government, notwithstanding that, studied the product and determined that it was safe and fully qualified for payment. And hence, that court vacated and reversed, ultimately, the $663 million judgment. So $1 billion has been reversed as a result of Escobar. And I think as we go forward, just because, again, the way Escobar interacts with the False Claims Act process in terms of how qui tam actions are brought, that there's going to be a continuation of really scaling back in terms of the number of successful qui tam actions that have historically been brought.
So Sandy, do you want to add anything on that?
Yeah, I do. I mean, I really want to pose some questions to Bob, because the Salas case, I commend to everybody to read Judge Mereday's opinion. Judge Meraday is the chief judge in Tampa, and he's a very, he has a civil background. He's been on the bench a long time, and he's a very reflective guy. The opinion is pretty extraordinary, and I sort of, is it on appeal now, by the way?
Yes.
So it's on appeal, so I don't know how much you can actually say about it. But if you, I'll read you a couple of excerpts from Judge Mereday's opinion. He says, Escobar rejects a system of government traps, zaps, and zingers that permits the government to retain the benefit of a substantially conforming good or service, but to recover the price entirely, multiplied by 3, because of some immaterial, contractual, or regulatory noncompliance. A principal mechanism to ensure fairness and to avoid traps, zaps, and zingers is a rigorous standard of materiality and scienter. And then he talks about Escobar. And in this case, I haven't read if you filed a brief in the 11th Circuit, but there was an amicus that was filed by a group of this is a nursing home case, but a group of organizations that deal with patients' rights and all. And their concern is that the government's traps, zaps, and zingers, and this sort of immaterial contractual regulatory noncompliance. In this case, the issue was whether or not Salas had systematically not, I think the issue, had systematically not secured comprehensive care plans for the nursing home residents, which people that have done nursing home cases know is a very important requirement that the care for in a nursing home is supposed to secure. And so I suspect that what the relator is going to argue in the 11th Circuit is, Judge Mereday's, off his rocker. I mean, nothing could be more material in a nursing home for care in a nursing home setting than the comprehensive care plan. Now, what he does do in this opinion, at least from my reading of it, he basically says no one complains about quality. No one complained about the surface, really. That was your point, that the regulators were ACO, which is the Agency of Healthcare Administration in Florida that regulates Medicaid. They were in, and I guess CMS was in, and they did all kinds of surveys and all, and there was no real, major findings. And in any event, they continued to pay even after and he makes a point in here that they continued to pay even after the case became public. And based on that, he says, well, I find that they can't, meet the requirements, under Escobar. And the other side says, well, good Lord, do you want the government to yank pay to nursing homes? I mean, these are the most, severely dependent people that we have in our society, and if you yank pay, what's that going to do for care? So, I mean, it's a really interesting, and so I'd like to know, to the extent that you can, sort of comment on some of those issues.
Yeah, and I think this issue, for any of you doing False Claims Act work, is really important. And let me kind of unpack, if I can, what I think was behind the judge's trap, zaps, zingers statement. And it kind of goes back to what I mentioned earlier in terms of the physician with the rubber stamp. So what you have here is skilled nursing facility. Of course, the skilled nursing facility has to pay for the property, the site that it occupies, has to pay for electricity, has to pay for laundry, has to pay for food, has to pay for staff, has to pay for the rehabilitation therapist. All that is reimbursed ultimately through a per diem, and a per diem is paid more depending on the amount of services that are actually provided at the end of the day. Assume it's $500 a day or so in terms of what the SNF is going to get. In many cases, it's less than that. But they're going to give that based on the service provided. So you take the allegation about care planning, and let's say the care plan has to be completed every 90 days. So an audit was conducted to find out whether care planning was conducted every 90 days. And what care planning would entail is that if a patient had trouble hearing, then you had to have a care plan in place to address it. And you would literally, so it'd be what is the defect, what is the plan, and what is the result of implementing the plan, in essence, is what you're doing with care planning. And then you review it every 90 days to still see if it's still applicable. So you'd have cases here where after the 90th day, the nurses are supposed to sign off and say, well, the patient had trouble hearing. The remedy to address that was to talk more loudly to the patient, and we need to confirm that staff has been trained on that and they're speaking more loudly to this particular resident on the site. Relators come back and say, oh my God, we audited that record and we don't see the signatures after 90 days showing that the care plan was reviewed. So therefore, your claim for payment is false, because in your claim for payment, you certify that you complied with all rules, regulations that are in existence, and you are recklessly disregardful and deliberately ignorant in ensuring you had a process to make sure that that care plan was done in 90 days. Now, as was mentioned, there's no contention. High quality of care, medically necessary services, no bad results were identified with respect to the patient population that was on trial. But what Relator wanted at the end of the day was a full per diem paid during a relevant time period back for the electricity, laundry, rehabilitation therapists, nursing staff, and everything else, ×3, plus civil penalties to address the fact that some nurse didn't initial the care plan after 90 days. And I think that's precisely what Judge Maraday meant by trap, zap, zingers, in order to turn kind of incidental, what Supreme Court referred to in Escobar as garden variety regulatory breaches, into massive treble damages, civil penalties, hundreds of millions of dollars worth of judgment. And that's the way, at least in my humble view, the False Claims Act was being abused previously, and how Escobar has really swung the pendulum in the other direction to really making the plaintiff wants to invoke an essentially penal statute to show essentially penal wrongdoing. And it's also will validate what Judge Maraday was looking for, which was what the False Claims Act attacks at the end of the day, or wants to ensure, is that fair value is paid for fair value services provided. So if you're covering the beneficiaries, high quality of care, medically necessary care, no defects in care, don't try to get hundreds of millions of dollars because a care plan wasn't initialed.
So Jack, we all want the robust materiality standard that Robert has detailed, and given a couple of great examples of how that has impacted favorably from a defendant's perspective False Claims Act investigations. But there's a flip side, right? So Judge Meriday also said in that case that government officials paid and continue to pay to this day despite the disputed practices long ago known to all who cared to know. So what impact has that had to your knowledge, or have you seen where the government might make some payment suspension decision where but for the decision in Escobar they wouldn't have? And is that a concern for providers?
It is for me. I've recently had this happen in 2 different cases where early in the investigation CMS came in and suspended. And I don't know, Bob, whether you've run into that, but if they don't suspend, just as Bob and Sandy were outlining, and they make payments on the claims at issue, is that going to come back to bite DOJ at trial in terms of disputing the materiality element? I'm having a lot of difficulty, quite frankly, with CMS. Dealing with them is not easy to do, much less to get any response whatsoever. And Bob, I don't know if you've run into that, but it is I'm seeing that happen now, post-Escobar. Well,
and Kristen, I think you can weigh in a little bit on that issue and some other interpretations of materiality post-Escobar, and especially on the issue just raised by Jack.
Yeah, I can, and not in the healthcare world as much, but I handled a case recently in the Northern District of Georgia, a government contracts fraud case where it was U.S. versus Agility Public Warehousing Company, and we really, in our motion to dismiss, really argued strongly that we thought that the alleged misstatements were not material. The government had renewed the government contract at issue for many years. There had been transparency in the disclosures that had been made in the context of the contract, and they continued to pay and they continued to renew, and there weren't any suspensions of payment or anything along those lines, quite to the contrary. But Judge Thrash didn't agree that those factors were enough to show that it wasn't material. And on the government awareness point, it was interesting. He found that just because there had been a key TAM filed in 2005, that didn't necessarily put the government on notice. DLA, who had the contract with Agility, was not thought to be on notice, even though DOJ had the allegations many years before. So I would agree that although the pendulum is swinging, not entirely.
And have you, whether it's healthcare or non-healthcare, experienced other post-Escobar decisions at the circuit court level?
Yeah, not me personally, but the Ninth Circuit, for example, has had a bunch of post-Escobar decisions, and there too recently just found materiality not to be enough to grant summary judgment. So I think that you are still seeing a split among the circuits, particularly on the materiality question and what will be enough to show that it wasn't material.
So, we're all used to having the government be required to prove materiality in white-collar cases and insider trading cases, and the standard does seem to be enhanced in some of these False Claims Act cases. And other issues that we're seeing arise in False Claims Act issues that also have implications in criminal fraud cases that, Jack, I'm going to ask you to speak about, have to do with falsity, objective falsity, and knowledge. So for a long time, with respect to False Claims Act cases, the government would try to do an end around of, if they were able to prove falsity, that they assumed that the company or the defendant had knowledge. And I think particularly post-Escobar, that's been unpacked a little bit. Jack, we're very happy to have you here for a lot of reasons, but I think one of the biggest ones is AseraCare. And just kind of taking a step back and giving a little bit of history pre-AseraCare. It's not the first time that a court had addressed the issue of whether something was false, whether something was objectively false. And what that standard is has evolved, and I think it will continue to evolve if and when we get this 11th Circuit decision on AseraCare.
Well, and I think By the way, Brian asked me to speak about 6 months ago, and he said, surely we'll have the AseraCare opinion by then.
And you said yes.
I said, I'm optimistic, but here we are. So a little history on it. I may have spoken about it last year, but this is a hospice case. Key Tam filed originally in Milwaukee, and then a second case in Birmingham, and a third in Atlanta in fairly quick succession and in that order. Ended up being transferred to Birmingham probably around 2010, so it's been a long time in the works. But the key issue is whether or not the medical records relating to the patients in the statistical sample that the government pulled, whether they supported the terminal prognosis of the patients. So what the government did on their pull, they pulled a sample of 233 patients, each with a length of stay of at least 1 year on AseraCare's hospice program. Their expert took a look at those medical records, and he concluded that 124 of those records did not support the certifying physician's terminal prognosis. The judge, at some point, I forget now just when, but on our motion, she bifurcated the trial, setting phase 1 solely on the issue of falsity. And then everything else, knowledge of falsity, damages, extrapolation, if that came into play, would be in phase 2. We never reached phase 2. What had happened was that the government had represented in answers to contention interrogatories that on the issue of what evidence did they have of falsity, how did they intend to prove that, their answer was, we'll prove it strictly on the medical records and our expert's opinion. They represented that a number of different times to the court because that was a hot issue, and ultimately we moved toward trial, and the judge decided to hold them to that representation because we really had litigated the case around that representation, and that was really the basis for the bifurcation. Tried the case over the phase 1 over a period of 8 weeks. The jury then returned answers to special interrogatories, finding many of those claims to be false. That is, finding the medical record did not support the terminal prognosis. We then reconvened with the judge. She gave the jury a few days off. We reconvened and to talk about phase 2 and getting that portion of the trial moving forward and scheduled. And I'll never forget, she walked into the room, into chambers, and she said, okay, this is going to be a very interesting conversation. And she said, I have concluded, I've been racking my brain about this outcome, and she said, I have concluded that I've committed a reversible error in not granting the jury charges that we had requested. Basically, that there needed to be objective falsity, and that a mere difference of medical judgments between experts was insufficient to establish falsity. Issue became what to do about it. We moved orally for a new trial. She granted it on the spot, clearly having made up her mind. And then we reconvened a few days later, and she said, I've been researching this further and considering the evidence, and I've preliminarily concluded that the government really proved nothing on falsity. And I'm inclined, pursuant to Rule 56F3, to grant sua sponte summary judgment. There were a lot of rule books being flipped under the table at that point. I was amongst them. And sure enough, there it was. So under 56F3, you have to give the opposing party time to brief. We then briefed. Ultimately, she entered the following March a summary judgment in our favor. That's now been briefed and on appeal. We argued that back in March of 17, so we have been anxiously awaiting some opinion from the 11th Circuit on it. It was a very interesting case and argument, certainly. But
hey, Jack, what about the interrogatory responses were most troubling for the court?
Well, I think that the fact that number one, they were quite clear that their evidence of falsity was strictly limited to the medical records of the 124 patients their expert found to be ineligible from the sample, and that it would only be their medical expert after the fact review of those in his opinion that would establish falsity.
As opposed to having the clinicians themselves testify.
Yes, they put up no clinicians, they put up no physicians who had certified at all. So she held them to that at that point. And ultimately, she did give them the opportunity to offer evidence that would connect falsity to any particular patient otherwise. And they finally acknowledged that they had no other evidence of falsity as to those 124 patients. So, you know, if the government's going to prove their falsity case on a sample and then attempt to extrapolate later to hundreds of millions of dollars, I mean, certainly the 11th Circuit case law is clear, Clausen perhaps beginning that, the sine qua non, you've got to prove falsity in the claim itself. And they said, we have no other evidence of falsity as to any of these patients. We have no evidence that anything in these medical records are false. We have no evidence from any of our clinicians that any of these patients were not terminally ill. And so she held them to that.
Well, you know, and I think what's one of the things that's interesting about AseraCare is the overall theory of liability. And Robert or Sandy, I wonder how much you all have seen this, but you know, historically, theory of lack of medical necessity has not been the most successful from the government's perspective, particularly in the hospice setting when there is so much subjectivity involved. But here you clearly have the government coming in, trying to exercise their retrospective clinical judgment on the basis of one expert who is going to summarily say that there was falsity.
Well, and let me add a couple of points from the case. It's very unusual for a couple of reasons. First of all, hospice, as you mentioned, Brian, I mean, the guidance on hospice, it's probably, I'm not sure, and Bob and I were talking about it earlier, I'm not sure I've seen any other area of medical necessity of medicine of the standards that's so utterly deferential to a physician's judgment. The statute says it's based on the physician's judgment. All he has to do is certify. The regs mirror that. And then the regs say, basically, doctor, we're not going to tell you how to reach that judgment, but when you do it, consider at least the primary diagnosis, all other comorbid diseases, all secondary conditions, all subjective and objective medical findings, all medications, and as long as you do that, you're good. So there is no kind of objective standard. The government tried to rely on LCD guidance. They finally admitted those were not binding. And the LCDs in hospice, in any event, say, okay, if you meet these elements, these criteria points, patient is eligible, but the patient can be eligible even if they don't meet these points. And again, deferring even in the LCDs themselves to the physician's clinical judgment. So in hospice, I think it's particularly judgmental as a matter of law. And, you know, predicting, you overlay that with, you know, it's not like a doctor diagnosing today, does this patient have pneumonia? If so, is it simple pneumonia? Is it complex pneumonia? This is diagnosing every condition in combination, assessing the combined burden of those things on that unique patient. And our patients averaged about 85 years of age, and then making a prediction into the future as to whether or not you think it's likely they're going to die in the next 6 months if that combined condition runs its ordinary course, whatever that means. So I'm not sure there are other areas of medicine that are that extreme. The other thing I was going to mention is that the government expert in his testimony said, well, this is my opinion, this patient is not eligible, they're not terminally ill. But no, I can't say the other opinion of the certifying physician was wrong. And he couldn't say that our experts' opinions were wrong. And then as to 10 of the patients in the sample, he actually changed his position. And I don't know why he did this in his testimony, but when asked, well, which time were you wrong? He said, I wasn't wrong either time. When I said the patient was eligible, I was right. And when I said the patient was ineligible, I was right.
Good answer.
So we had a very unusual set of circumstances combined with the bifurcation. So that's really what the judge was looking at. Government, what have you actually proven on the element of falsity?
Robert?
Yeah, just one quick point on medical necessity. In case any of you folks do one of those cases, especially in the False Claims Act context, they are generally very easy cases to win. I've won a couple against the government, United States versus Purdue and United States ex rel. Lawson versus Aegis Therapies. And the reason they're easy is sometimes the clinician will be picked out because they use a particular billing code at a higher frequency than their peers. And so the government will think that they're upcoding because the clinician at the end of the day can't rule out that its patient population is any different from the peers. The reason those cases are easy at the end of the day is the clinician has skin in the game. So they will go through the medical record very carefully and be able to generally identify why they thought that enhanced service was needed for that particular patient. And as you, as the lawyer, go through each and every claim with the physician at the end of the day, and again, these cases, usually False Claims Act cases, as we used to explain when I was at the Department of Justice, they're all gray. If they're black and white, as we would explain as DOJ lawyers, it'd be criminal matters. Just the fact that the criminal matter was declined and we're here pursuing the civil fraud remedy should tell you it's in a gray area. Once you have the clinician there testifying and can connect up the dots, usually not only can you win, but in the Purdue case, which had to do with the pulmonologist, the district court judge was so outraged by the government's action, it actually sanctioned the government, and our client got back $500,000 in attorney's fees. So they're really cases. If you get a medical necessity case, you should. Those are ones that you can generally win.
So last year, at this program, we talked a little bit about a perception that there were some expanding theories of liability from the government's perspective in both civil and criminal healthcare fraud cases. And Sandy, I want to ask you in just a minute about some examples of that. But before we leave the issue of medical necessity, I think there's an important criminal case along those lines, United States versus Paulus, which I think the Sixth Circuit just issued its decision just a month or two ago. And, you know, I think that the criminal defense lawyers, Robert, probably thought it was going to be easy to win. They lost at trial. The district court judge overruled the jury's decision, and then the circuit court just issued an opinion that I think is of interest on this topic.
Yeah, I was going to ask Jack how that opinion, it's a cardiologist that was prosecuted essentially for doing what the government said were unnecessary angiograms and stents. And the alleged false representation or statement was the percentage of blockage or stenosis. And the government's position was they had an expert that testified and said that in his opinion, they were only 20 or 30% blocked, and there was some suggestion that there was some standard that it needed to be 70% blocked, but it was not clear whether that was really a standard or not. And the jury convicted, and the judge overturned that conviction and essentially said you haven't proved falsity, because basically the thing I learned, the judge said from trial, is listening to the experts, it's subject to interpretation or opinion, and that's not enough. And the Sixth Circuit said basically just the opposite. We believe we were clear, and they cite a case, but we want to make it explicit now. The degree of stenosis is a fact capable of proof or disproof. A doctor who deliberately inflates the blockage he sees on an angiogram has told a lie. If he does so to bill a more expensive procedure, then he has committed fraud. So how does that square with your case, Jack, where it does seem like the government's evidence is essentially expert opinion?
And let me add a little bit more color to it. In his argument to the district court judge, Dr. Paulus, he pointed to testimony of government witnesses at trial to establish that cardiologists often disagree with one another about the extent of stenosis and the appropriateness of stent procedures. He argued that the government's circumstantial evidence falls short because the government's presentation of internally conflicting patient testimony, the volume of stent placements, and his compensation do not permit a reasonable jury to conclude that he had the requisite fraudulent intent. And so I think the idea is that there can be a mere difference of opinion as to experts when you're looking at the angiograms as to what the level of blockage was.
And to answer Sandy's question, Sandy is clearly distinguishable. They did pop in immediately filed a 28J notice with the 11th Circuit, and you get like 350 words, and we responded pointing out that it's distinguishable. But I do think it is. And as I mentioned, diagnosing pneumonia, for example, as a single diagnosis, while there may be some judgment in that, there are clinical tests that can prove that one way or the other. The Paulus case was, as Sandy outlined, estimating the degree of blockage in the artery around the heart. They cited to the American Hospital Association, or Heart Association rather.
Right.
They have a standard of about 70%. If it's 70% blockage or above, you can stent. If it's somewhere between 50 and 70, it may be okay. If it's below 50, it's highly questionable. The circuit court pointed out that there was direct evidence of falsity in that case. There were people that knew the doctor and witnessed his procedures who said he was just blatantly falsifying information. They found him to basically be lying about it. There was also some what do they call it, inter-observer variability. There's some science on that yes, there's some degree of opinion about it, but generally it doesn't vary more than about 20%. And some of the evidence was, from the government's expert, it was 20 to 40% blockage, and Dr. Paulus might be at 80%. So there were some issues there. The court also, the Sixth Circuit, I think my interpretation of this citation to AseraCare is that it was approvingly. Sixth Circuit said, but opinions are not and have never been completely insulated from scrutiny. At the very least, opinions may trigger liability for fraud when they are not honestly held by their maker, or when the speaker knows of facts that are fundamentally incompatible with his opinion, citing to AseraCare in a parenthetical note, holding that certain good faith medical diagnoses by a doctor cannot be false. There was no evidence in AseraCare of bad faith certifications by any doctors, and I think that's another distinction here.
A point on this, if I could, to add to Brian, we tried to study this question academically in the context of a couple of cases, meaning take a population of objective, expert clinicians to see which codes they assigned in different types of coding, and to see is there sort of a normal rate of disagreement, just because experts are going to disagree on this stuff. And of course, it's highly variable based on the type of coding, but what we were finding was that in the type of coding we were looking at, there's kind of a 5 to 10% sort of normal rate of disagreement. Not that anybody's right or anybody's wrong, there's a degree of judgment involved. And what we tried to argue was that in this repayment situation, the company really ought to only be liable for the disagreement or the variance rate above that sort of a normal rate. So this particular situation wasn't very conclusive, but it was going down the road of trying to point out and trying to quantify with some mathematical certainty that clinicians will differ about this stuff. And how do you deal with objective falsity in such a world?
Well, in talking about further the interplay between civil and criminal investigations, it used to be, at least it seemed, that more frequently than not you would see a declination of a criminal case that would then go civil. Sandy, Kristen, I'm going to ask you guys for some examples of the opposite, which we've seen recently, in which a civil key tam has spurred on a parallel criminal investigation, which ended up really taking over. And I think agility, there was some of that going on in your case.
Yes, Brian, there definitely was. The case that had started as a key tam and was investigated for some time ultimately segued into a criminal case alleging various kinds of government contracting fraud, and that case really did take over, and the criminal or the civil case at that point took a back seat. The company was located in Kuwait, and so from both perspectives, but from the civil perspective and service, they really didn't make many efforts at service while the criminal case proceeded, and then only much further down the road did the civil case start to heat up again, and did they try to serve the matter. So yeah, it was interesting in our case where the key tam really did take a back seat and really was in effect stayed for several years while the criminal case was really at the forefront.
I mean, there are numerous examples of criminal cases that started as key tams. I mean, the Columbia HCA case where I represented Columbia 20 years ago, I mean, the key tam stayed under seal for, 10 years or something like that. I mean, it was a massive case, and it happens. I think the case that Brian was referring to is a case here in the Northern District of Georgia. It's a case that Brian's very involved in and Rick Dean is involved in, and it's a case that involved Tenet Healthcare and several hospitals that at the time they owned, that operated in the Atlanta area, and one was in South Carolina. And it started as a key tam in the Middle District of Georgia, I think, and it turned into a criminal investigation. It's still pending. There are 2 hospital executives have been indicted. There was an enormous amount of pressure that was put on Tenet, sort of along the lines of what we've heard in some other panels today, and they ultimately did a resolution that included guilty pleas for some hospitals that were subsidiaries. They were able not to get debarred, and paid just an enormous amount of money, $500 million, I think, with a CIA, and these 2 executives, unfortunately, from my perspective, have been indicted and in a pretty aggressive manner, and are going to have a trial sometime probably in the next year. And all of it arose from it's an interesting case because it's basically a kickback case, and there was an organization called Clinica that provided clinical services for undocumented women that were pregnant, and those women under a particular program were entitled to certain Medicaid coverage for emergency, i.e. Deliveries, and the allegation is that the Tenet hospitals entered into what the government claims are protectual contracts, but contracts with this clinic to provide various consulting and other management services. And the allegation is that the clinic referred business, and as a result, fraud occurred, kickbacks occurred, because allegedly the protectual relationship was based on referrals. All of this arose from a key tam that pended for quite a while. So I think that's what you were talking about.
I thought you were going to talk about WellCare.
I could have talked about WellCare. That was even worse.
Well,
But,
and just
we'll eventually
if you
talk
don't
about
mind,
it.
and using United States versus Whiteside, a 2002
Okay.
Case out of your home district as a backdrop, just if you don't mind, Sandy,
So-
talk a little bit about.
So Whiteside is the Columbia HCA case, and in that case, a few executives got indicted, and they got convicted, and the conviction was overturned in the 11th Circuit because the circuit concluded that there was no actus reus, that there was no falsity, because the alleged false statement was based on what was consistent with a reasonable interpretation of a regulation. And so basically what the court said was, if the statement you make, if the thing you do, that case had to do with how you classify debt, but if the statement you make is based on a reasonable interpretation of a statute or a contract or a rule, then there's no falsity. And it's consistent with a number of cases over the years where courts have pushed back when the statement is based on a rule that is ambiguous, or a statute that is ambiguous, or some contract provision, and you have a debate as to what it means. And we know every day we have contract cases, and the plaintiff says that it means this, and the defendant says it means this, and eventually a judge decides it. But should that be the basis of a false statement case. You know, if there are reasonable interpretations that vary. And so that was, that was a very important case in the 11th Circuit, Whiteside. Well, fast forward to 2015, the WellCare investigation, which is a case that also emanated in Tampa. WellCare is a big HMO. They were a big Medicaid provider. There was a behavioral health program that was financed by Medicaid, and basically there was a state statute that was passed, sort of at midnight, that was never debated or anything. And essentially what the statute said is that in this program, that 80% of the funds that go to, in this case, an HMO, should be, and the language was, expended for the provision of behavioral health care. And so, and there was never a rule, there was never a regulation, there was never a court ruling, but the question was, what the hell did that mean? Expended for the provision of behavioral health care. And in the mental health industry, most HMOs didn't directly provide behavioral health care. They would contract with what's called BHOs, or behavioral health organizations that specialized in that, and they would pay them typically a subcap. So this was a capitated system, and so the HMO would get a capitation to provide the health care. They would subcapitate, or they would subcontract with a behavioral health organization, and would pay them typically 85% of whatever the capitation was, and then the service would be provided. And the question was, when WellCare in this case, as did many HMOs, created their own behavioral health organization. And so the government came in and said, you have committed this massive fraud because you are subcapitating to your own BHO, and therefore you're filing a report that said you spent 85% or 80% based on the subcapitation, when in fact you only spent X number of dollars. What it actually costs to for direct care, and that's what the whole case was about. And frankly, the trial took place against the two individuals, went on for 4 months. The jury was out for 21 days. They took a vacation during the judge. They were hung, totally hung. The judge gave them 10 days off over Memorial Day weekend, and they came back, and a few days later they had this mixed verdict where nobody was convicted of conspiracy, but everybody was convicted of 1 or 2 false statement counts. And frankly, I and a lot of people thought that it would be reversed in the 11th Circuit under Whiteside, because the argument, the defense is that, hey, this language that says expended for the provision of behavioral health care, that's subject to interpretation, and it's never even been interpreted, and our interpretation was reasonable, that we could do what we did. And the 11th Circuit, in an opinion that was very long, it's called United States versus Clay, Farhar, Behrens, and Kale, just basically blew off Whiteside. I don't think they didn't reverse Whiteside, but they just blew it off. They said, well, they said it was clear. The language was clear. And, it wasn't, but that's what happened.
So I want to conclude in talking about a couple of sort of DOJ policy changes, but before we do, I want to just take a minute to talk about some recent developments in the government's attempted use of statistical sampling, which could potentially impact some due process concerns. And Jack, we've talked about, obviously the government for a long time has used statistical sampling and extrapolation to prove damages, right? And we've seen over the last 12, 18, 24 months a relatively new phenomenon in which the government is now seeking to use statistical sampling and extrapolation not to prove damages, but to prove liability, with the argument being, well, hell, there's too many claims. We can't look at them all, right? We'll use a statistically valid sample, come up with a sample size, extrapolate it, and then that's what we'll use to prove liability.
Well, that's right. And it really, in these cases, particularly these healthcare cases where there may be thousands of small claims. The government's argument with the court is we won't be able to enforce the laws, and if we have to prove every claim, they're not very receptive to due process responses from defendants. But probably the two key cases out there are the life care case up in the Eastern District of Tennessee. Judge Matisse ruled in that that evidence could come in to prove by inference, by extrapolation, both actual liability under the False Claims Act, stating that providing individualized proof would require the devotion of more time and resources than would be practicable. And then he also said, while defendant makes several compelling arguments regarding the inherent limitations associated with statistical sampling, these arguments are better considered by the fact finder rather than the court. That case subsequently settled after that. The other case is the Michaels, U.S. ex rel. Michaels versus Agape Senior Community up in the South Carolina. That was a case where the judge held otherwise. The district court judge ended up certifying the issue. He was not going to permit it to come in to prove liability. And it went up to it was a non-intervened case. Apparently they had reached a settlement. The other issue was whether the government had say-so over that. Ultimately, the Fourth Circuit decided not to take up the extrapolation issue. I think they said they granted that improvidently and they just kicked it back.
They punted.
They punted that, and after that, that case settled as well. I will mention the Wall versus Vistacare case out in Dallas, another hospice case kind of on the backside several months after the AseraCare opinion, and Judge Barbara Lynn out there, what I think is a well-reasoned opinion, rejected the use of extrapolation, saying that the review of the patients was just too individualized to be able to do that, and rejecting the methodology. She found problems in the methodology as well and rejected it on that basis.
Jack and Sandy, in a minute, I'm going to ask you guys to talk about the Granston and Brand memos. But before we do, just sort of a practice pointer of a relatively new development which implicates False Claims Act settlements and potential tax implications, Tom.
Sure. So some may be familiar with the section 13306 of the Tax Act that has changed the tax deductibility of settlements in the False Claims Act situation. For those who've been involved in it, there's been a lot of disagreement in the years over what portion can be deducted of a settlement, with the idea being mostly that it's the piece that's compensatory to the government. What was the government's economic harm? And for those who've been involved in negotiations, there's a lot of back and forth, and both sides always start out with a very principled analysis of the economic harm and apply multipliers. But by the time you get to an actual settlement number, there's a lot of horse trading, and you kind of lost track of what people's actual view was of the economic harm. So I've worked with a number of clients where they have to go back after the fact and reconstruct the settlement negotiation to demonstrate what their view of the economic harm was, because that's the portion that they can deduct for settlement purposes. So I would just note, we don't really have time to get into the details here, but just note for folks there have been some changes and some clarifications with the latest Tax Act that talk about, again, what piece is deductible and which is not. The other thing I would note is just an observation, something we've seen popping up lately, is where the IRS has come in after the fact, after a settlement, and pointed out, this is in the context of a kickback case, but raised the point that, dear company, you just essentially admitted that all of these marketing expenses were really kickbacks. Therefore, you shouldn't have been deducting them on your tax returns all these years. So going back and trying to reopen some series of prior periods to look at them. And that, too, very similarly involves having to go back and reconstruct the whole settlement negotiation, figure out which of these, of the settlement amount we paid, how much of this really was prohibited kickback type expenses.
So Jack and Sandy, I know that you both have recently had some higher level conversations with Department of Justice officials regarding recent policies on reliance on sub-regulatory guidance to advance False Claims Act cases, and also potential government involvement in meritless cases brought in FCA cases. And what's the latest from your perspective?
Well, so we have this DOJ dialogue group that the ABA criminal justice sections had for a number of years, and with the exception of AG Gonzalez, all the other AGs since the early 90s have met with folks that through the criminal justice section, and Jack Selden has chaired that group for the last few years. And we met recently with Attorney General Sessions and Rod Rosenstein and various other folks from their group. And one of the things we raised with them was the recent memo that was issued by Rachel Brand when she was still there. She headed up the Civil Division of Justice. It was issued earlier this year, January 25th, 2018. It had to do with limiting the use of agency guidance documents in basically False Claims Act and other affirmative civil enforcement cases. And the essence of the memo that she issued was that basically it says that department litigators may not use non-compliance with guidance documents from various agencies as a basis for proving violations of applicable cases like False Claims Act cases, which was surprising to all of us because, take the WellCare case I was talking about. There was no rule, but there were various things that the government was relying on in that case that had come out of the agency, not through the rulemaking process, but that was sub-regulatory guidance. And so we raised that with Attorney General Sessions, who deferred to, that would be a polite way of putting it, to Rod Rosenstein. And we asked, where does this apply to criminal cases too? Because if it only applies to civil cases, what about, we gave them some examples. What about these criminal cases where, a lot of the evidence is basically, anecdotal or sub-regulatory guidance over the years from the agencies? We didn't get an answer, but Jack, you may have some update on that, right?
Yeah, I think that was a good description. What we explained was we find it to be anomalous. You can have no civil liability, but you can be convicted of criminal acts based on that. Shouldn't there be some consistency here? And by the way, when our committee goes in, we're not grilling the Attorney General or the deputy or anything. We're bouncing ideas, and they've been very receptive to having these meetings and these conversations. At the close of the meeting, one of the deputy, Rod Rosenstein's principal deputies at that time, Zach Terwilliger, who's now the acting U.S. Attorney in the Eastern District of Virginia, I had been communicating with him a little bit about it because we didn't want to walk in and just drop this issue. And on the way out, he said, this is an issue where we've got a group examining currently. And that was the last I heard.
Well, on the last issue on Granston, we talked a little bit about whether it would actually have an impact, right? And it's always interesting to see with these Department of Justice policy changes whether they actually will or won't. And Robert, I'm curious to hear your experience or what your predictions are. And Sandy, it sounds like with your practice, you have had some experience with that already. Well,
Granston, just so people know, that's another one of these memos that was issued, by sort of the new Justice Department on January 10th of 2018, issued by Michael Granston, who's Commercial Litigation Branch Fraud Section, to attorneys in DOJ, and it has to do with the factors for evaluating dismissal of key TAMs, basically pursuant to a particular provision of the False Claims Act. And basically what he does, it's a really interesting memo. He sets forth various examples of where it would be appropriate for DOJ, even though they haven't intervened, to move to dismiss key TAMs, where there were meritless claims, preventing parasitic or opportunistic actions, preventing interferences with agency policies or programs, controlling litigation brought on behalf of the United States, preserving government resources, safeguarding classified information, addressing egregious procedural errors. So there's a number of examples. And we had a case actually not too long ago in Tampa where we finally convinced the U.S. Attorney's Office to intervene for purposes of moving to dismiss this, what we believed was and I think the court believed was a meritless case.
Yeah, the only part I would add is the way at least going back to the time I was at DOJ with the civil fraud section, the significant impediment, at least back then, was always Senator Grassley and his perceived closeness to the relators bar. And there was a great fear that if DOJ, when it declines to intervene as a non-party in the case, starts dismissing these actions, it would create the appearance that DOJ is in cahoots or had been cohabitated by the defendants and defense industries. And not only that, but then responsible governmental officials would be hauled before Senator Grassley to address those concerns directly. So there's a political basis for DOJ's historic reluctance to move in to dismiss frivolous cases. And I think as long as Senator Grassley stays within the Senate and he perceives the False Claims Act as being his baby, I think that reluctance will continue in DOJ, notwithstanding memos that it might issue periodically otherwise.
Well, before we conclude, does anyone have any questions for the panel? Yes, ma'am.
I'm wondering whether you're aware of any instances in which the relators bar is attempting to collect discovery from DOJ about its decisions to dismiss PTM cases, and if so, how do you think that's going to affect that decision-making process by you?
Well, where that typically comes up is that the relator is afforded an opportunity for a hearing, generally upon the dismissal, and there's a circuit split on that precise issue. So the DC Circuit, for example, says that, in essence, DOJ has unfettered discretion, and just by virtue of the constitutional command that the Attorney General shall take care that laws are effectuated, so that unless the relator can show that the government has been corrupted in some fashion, or responsible governmental decision makers have been bribed, or their judgment has been corrupted in some other fashion, the court's not going to permit any discovery by the relator. Now, the Ninth Circuit in the Sequoia Orange case, of course, goes in a different direction and is at least left open the possibility that discovery can be available in appropriate cases to determine whether the government's exercise of discretion was arbitrary and capricious, which is a lower standard. And there's other courts that, most of them say they need not decide whether they join the DC Circuit or the Ninth Circuit, but even using the lower standard of the Ninth Circuit, have always uniformly in every case have validated that the government can decide to dismiss a qui tam case, and have had a high threshold on allowing relators discovery of the government's decision-making process prior to that point.
All right, well, I think it's time for a short break. Please join me in thanking this great panel.